Welcome to another RMA educational program. These are designed to help keep you up to date on topics relevant to doing your job. I'm John Martyr. I'm the president of the Orange County chapter of the Risk Management Association. We call it RMA, and RMA is a member-driven organization with now 31,000 associate members spread across 1,600 institutions. We have sort of a three-pronged approach to helping with the financial services industry. One is education, which is this thing that we're doing today, this and many others that we do, accessed by the associate members. We also have products that are designed to help you do your job better. And then we provide really a community for these 31,000 associate members that allows you to connect with each other, look at best practices, ask questions among your peers and that kind of thing. Our Orange County chapter makes these programs and all of our programs actually available through our sponsors, and you can see the sponsors on the screen, our platinum sponsors, so please take a look at that. For this program, we are so appreciative of Harriet Alexson for arranging Joe Liniak to come and speak with us. Harriet is an attorney at Lee, Hong, Degerman, Kang, and Wamey. I think I got that right, Harriet. And so again, thank you for arranging this today. Without further ado, I'm going to go ahead and get us kicked off with an introduction of Joe. Joe Liniak is a financial services partner at Dorsey & Whitney's financial services practice. He focuses his practice on regulation and operation of financial service intermediaries, provides counsel on strategic planning, the application and licensing, legislative strategy, and a number of things, commercial and consumer lending, examination, supervision, and enforcement of general corporate matters. Joe has an extensive background and a range of experience in these issues and has been before federal and state regulatory agencies, the FDA, Federal Reserve Board, OCC, FDIC, and others. His clients include foreign and domestic banks, savings associations, credit unions, holding companies, mortgage banking companies. So basically, Joe is an expert in what we're about to talk about. And so we are so grateful to have you there. I'm going to turn it over to you. By the way, if you have questions during the program, just go ahead and drop them into the chat. We're going to pick them up at the end of the program. So kind of give Joe a free rein to continue on with the program, and he may answer your question during the course of it as well. So anyway, Joe, welcome. Thank you so much for doing this today for us.
Oh, well, John, thank you very, very much. I appreciate it. I also appreciate Harriet's kind introduction to participate today. A couple of housekeeping thoughts. Next slide, please. Because of the fact that I'm a lawyer, I have to basically tell you that I'm providing you with some factual information regarding LIBOR and the death of LIBOR and the substitution of LIBOR, but it's not meant to be legal advice, and you should not be relying upon it. It gives you a general overview, which allows you to talk with your own counsel. If you want to talk to me, that's certainly fine, and then I will send you a bill and sign you up. But with those facts in mind, the other point is that we did a comprehensive deck for RMA, which we're going to be using today, and any of the folks here are authorized to be able to use it, provided they give us proper attribution to having drafted it. Next slide, please. Something, just so you know about Dorsey. Dorsey is got 20 global offices, and one of the things which we're proud of is that we've got over 250 lawyers that are constantly working in the representation of banking and financial service clients. So it's a very, very large financial service practice indeed. And a world-class lending operation, which is global. You can see that maybe you're a little sign of friends of my colleagues in Shanghai who are waving because they finally got released from, I guess, their month-long quarantine. So they're very, very happy about that, and I'm glad to see that they're being released. Next slide. What we're going to be talking about here is LIBOR. Oh, I see Harriet there. She's on. This is great. Hi, Harriet. We're going to talk about LIBOR and its termination, which has been on again and off and again, and now probably for all of us is going to be around June 30th of next year. So time is a wasting, and we have to start planning for it. We're going to start out with a short history of LIBOR. We're going to talk about the remedial action taken by both governmental and non-governmental entities and actors to be able to take action with when LIBOR was announced it was going to be terminated. We're going to focus a lot on something which should help most of us, the Adjustable Interest Rate Act, which we're going to refer to as the LIBOR Act, which was signed a few months ago by President Biden. And then we're going to finally finish up with an analysis of categories of financing contracts and approaches to compliance and risk management, which I think is a centerpiece, of this organization. So let's talk about a little bit about a short background, which is the next slide. And LIBOR stands for the London Interbank Offered Rate. It's a global floating benchmark interest rate, which is used in conjunction with a number of things, such as a margin to be able to set a current interest rate on variable rate lending. And it's calculated daily in 5 currencies: US, Europe, Japan, and so forth. And approximately in the derivatives marketplace, about 180 to 190 trillion dollars in notational value contracts use US dollar LIBOR. So we're not going to be talking about derivatives or swaps here. I mean, that's really the province of the financial markets, primarily in New York City. We're going to be talking about everything else, which is only 10 or 20 trillion dollars worth of contracts. So it's not really the tail wagging the dog, but in terms of what has driven the train here, it has certainly been the derivatives marketplace and the large number of notational contracts in that category that use LIBOR. LIBOR is determined each day based upon representations of panel banks as to the rate in which they could borrow on the London interbank lending market. And it's calculated using 18 banks, with the 4 highest and lowest submissions being excluded. Now, next slide. What happened in the last 20 years is that there was a reduction in actual LIBOR-based unsecured borrowings by large banks, and it created a reliability gap regarding the values, and they went therefore to these estimates done by the 18 panel banks. What that opened up was the opportunity for wholesale fraud on the part of bad guys who manipulated the rates. They were eventually caught. We realized that it's still very, very easy to manipulate LIBOR because it's really not a reliable value. And in 2014, international organizations, including those of the United States, began work on establishing alternative reference rates. The Federal Reserve Board created the Alternative Reference Rate Committees, also known as the ARRC, to identify reference rates to replace LIBOR. And you're probably wondering, what is the nature of the ARRC? Well, I've been a real cynic of it, and it's basically a bunch of guys sitting around a table, mostly in New York City, all of whom are considerably very important in their own estimation, and they went about under the auspices of the Federal Reserve Board, coming up with answers, again with a focus on the $180 trillion of notational value, not in terms of other types of transactions, which we are going to be focusing on. And in June of 2014, they announced, 2017, they identified the secure overnight financing rate, commonly known as SOFR, as the preferred substitute to US dollar denominated LIBOR. And importantly here, you've got to focus on the fact that SOFR it's an overnight rate based on repo financing rates. And that means it's a secured lending rate, whereas LIBOR is an unsecured rate. So the value of LIBOR takes into account credit risk, whereas SOFR doesn't, because the fact that it's a repo, you actually own the securities, and therefore your risk is minimal compared to an index that is unsecured. And also in 2017, the Financial Conduit Authority in Great Britain announced it will no longer compel banks to submit LIBOR panel recommendations after the end of 2021. And guess what? They weren't ready yet. They didn't crunch all their numbers. They didn't crunch all the systems that needed modification. And so that December 2021 number has effectively been now kicked back to June 30th, 2023. And panel banks are still submitting the information, or they're doing something close, which we're going to be examining a little bit, of something known as synthetic LIBOR. Next slide. Here, if you've got a magnifying glass, you can see asset classes affected by LIBOR, as put out by the Federal Reserve Board and ARRC several years ago. In a couple of categories, it's useful just taking a quick look at it. What are we talking about? Well, in terms of commercial loans, we're talking about $3 trillion of commercial loans that use LIBOR. In the case of consumer loans, close to $2 trillion worth of LIBOR-based loans. In terms of securities, likewise, very, very large numbers. And you can also see how the estimates were made about the runoff of these instruments over a period of time. And this has to be extrapolated now, looking at 2023 as the date when LIBOR goes away in most cases, and what the runoff will be under these classes. But as you can see, the runoff is not necessarily very, very quick. And so you're going to have these legacy contracts out there to be worrying about. Next slide, please. Let's talk a little bit about SOFR, the secured overnight financing rate. It's a risk-free rate that's correlated to other money market rates. It encompasses a robust underlying market of repo transactions with close to $1 trillion in daily transactions since April of 2018. So as compared to a LIBOR, where there wasn't a robust market, there were not frequent trades, making it a reliable source. This is very, very reliable and happens both in the United States and internationally. It's published at 8 a.m. every day. It's a daily rate. And notwithstanding that, several banks have objected, which we're going to get into, as to whether or not this is a fitting substitute, even though the Federal Reserve Board, which is driving the bus on this, has indicated that it should be. And as I mentioned, LIBOR is a fully transaction-based rate and has the widest coverage of any Treasury repo rate available. It incorporates a number of things: tri-party repo data, the fixed income clearing corporations repo data, and bilateral Treasury repo transactions cleared through the FICC, It's reported to the Federal Reserve Board on a daily basis. And so again, it's very, very robust in terms of its coverage. For those of you that are interested or have insomnia, there's a very, very good document put out by the ARRC, an updated user's guide to SOFR, again, put out by the ARRC in 2021. And again, it's not stifling in terms of its economic data, but if you need more in-depth information about it, it's a very, very good good starting point. Next slide. Just so you know, LIBOR is not, I'm sorry, SOFR is not the only rate that is out there. Other national jurisdictions have come out with their own versions of index alternatives. We've got the British one, which is known as SONIA, the Tokyo rate, the Swiss rate, the Euro overnight rate, and the entity that heretofore has been calculating LIBOR, the ICE Benchmark Administration, has been making noises saying that it may continue to calculate a modified LIBOR, which some people are calling a synthetic LIBOR. I know what you're thinking. Well, wait a minute, if they're still announcing it, does that mean that it doesn't go away? And again, something which we're all going to have to consider, but it is now out there. And then other folks have raised their hands and saying, you know, the SOFR is not useful to us. And one is the Ameribor index created by the American Financial Exchange, which has got a credit component to it, and it's made up of several small and medium banks, which some folks have adopted for purposes of non-derivatives based lending as being more realistic, and has got some real advantages to it, which we can talk about in a little bit. Next slide. All the acronyms, and there's not going to be a test on this, but there's a lot of people sitting at the table, again, pounding their chest and saying, you know, we're important and we need to do this, including the ARRC, the Federal Reserve Board, which has taken the ARRC, created it under its own aegis, ISDA, which I'm sure many of you are familiar with, and they've done an excellent job in terms of promulgating forms for purposes of swaps and derivatives contracts. The federal banking regulators, who have taken somewhat of a hands-off approach, saying, be prepared, but we're not really going to be beating you up yet about dealing with LIBOR, but we want to make sure that at least you're proceeding to think about it. The Financial Accounting Standards Board, which is important in terms of how do you recognize gains or losses on the replacement. IOSCO, and then British regulatory authorities, who may have been driving the train, but certainly it's been taken over by the Federal Reserve Board and the ARRC in terms of US dollar LIBOR replacement. And under them are several entities, which again, very, very prominent in terms of financial marketplaces. Next slide. Okay, so who calculates SOFR? The Federal Reserve Board appointed the CME group to calculate SOFR forward values and tenors. And again, we're not going to get into too much detail about tenors or forward values, but even though SOFR is a daily rate, they've come up with forward-looking and in arrears values of SOFR for 1 month, 6 months, 3 months, and now 12-month values. And the most recent, the 12-month value, was authorized as of May 19th which was just a couple of weeks ago. So you're sitting back saying, well, wait a minute, if we're doing a replacement index, aren't there several values of the same index? That's a good question. And we're going to see what the answer is down the line. But we have got some degree of complexity in terms of what you can choose, what you must choose. But I will say one thing, again, which you need to know about. The CME group, even though it has been authorized to be the calculator of SOFR requires that you get a license in order to use their calculations. Now, they have waived all fees until 2026, so doing it probably makes some degree of sense. I frankly think that it's something that should not be a fee created for a private entity, but I was outvoted on that. So, but it's something, again, which is a bell and whistle, or at least a belt and suspender, which you need to look at if you're going to be using those values for purposes of calculation issues. Now, a couple of concepts to understand that about what's going to be taking place. And I will say initially that when you go back over the last several years, there's some nomenclature issues which have slightly deviated. So you have to be aware of them, in that whatever you're looking at, depending upon the date, may have been substituted for, and a new term may be substituted. The most important of which is, replacement for a triggering event. A replacement event requires the replacement of one index with another. Then you have the fallback. And the fallback is that, assuming a triggering or replacement event occurs, what does the instrument provide that will happen in respect to the replacement of one index with another? Then you have the index itself. And here we're talking about LIBOR. It's the thing that's going to be going away, and it's used for purposes of determining interest rates in conjunction with a margin. Now, I would also emphasize, anyone listening to this, underscore the use of the term margin, because there is a real problem in a lot of documents that don't necessarily discuss adjusting the margin. The smart ones do. Maybe the ones that didn't think this would ever happen did not. And so you've got an issue where the value of SOFR does not track the value of LIBOR. And if you can't adjust the margin, you may have an issue which we're going to talk about right now. Okay, so what happens? A replacement event occurs, and LIBOR as the index gets replaced by a new index. And the ARRC has recommended SOFR as a successor for US dollar contracts. As I mentioned, there's several different tenors. There's forward-looking, there's SOFR in arrears. I mentioned a little bit about how it's calculated. The calculation methodology is very, very complex, and if you've got an economics degree, good for you. I trust them in terms of their calculations. But because of the difference in nature between a secured and an unsecured rate, the ARRC has recognized the importance of a so-called spread adjustment. And a spread adjustment would adjust for the credit risk embedded in LIBOR and for the absence of a credit component in SOFR. And this has generated a great deal of discussion, because the attempt here is to get around the margin issue, where margin may not be adjusted because it's not in the loan contract, and also takes into account a closer correlation between the value of a chosen value of SOFR and the tenor and the value of LIBOR that's being substituted. Now, why is this important? Next slide. Well, when a simple move from LIBOR to SOFR creates a move to a lower index, and if the margin remains constant, the debtor has a lower financing cost, meaning this change would result in the debtor gaining the equivalent to the value adjusted. Alternatively, if the instrument permits, the margin could be adjusted to avoid the transfer of value from creditor to debtor. And again, the value adjustment of SOFR that we just mentioned is an attempt to address this issue, but it also creates problems necessarily down the line as to the authority of you to be able to do it. Well, why has it become important? Let's go to the next slide. You will see here differences between the prime rate, the treasury rate, and 1-year LIBOR. And the issue becomes, who pays for the delta? Can you adjust the margin? Is there an adjustment to the value of SOFR and the tenor that's created? That's the big question. Are you made whole? And I will also mention the fact that up until 3 or 4 months ago, before inflation hit us and before the Federal Reserve Board began to raise interest rates, a lot of folks were saying there's really not that big a distinction between LIBOR and SOFR. But since we may be heading into a recession, and since we are being subjected to increased Fed funds rates, we may see a fluctuation in the index values between SOFR and other indices. And again, so some folks looking on a forward basis may say, okay, I can deal with SOFR, maybe I can deal with the adjustment, but am I going to be losing interest if down the line, because of inflation, interest rates go up and I'm stuck with a interest value, index value, which moves more slowly than the rate of inflation and so forth. Something, again, has to be considered. Another unusual component, next slide, is what occasionally happens with SOFR, and for certain technical reasons in terms of financial reporting, every now and then SOFR jumps. And in December of 2018, it jumped 80 basis points. And if that was the date that you made a replacement using SOFR, you're going to have people screaming bloody murder saying, I've been jobbed. And so what do you use? How do you use it? Who wins or loses? The investor, the creditor, or the borrower? Next slide. The same thing. In 2019, there was a spike. And again, depending upon when you're making a substitution or a replacement, you could have potential litigation. Next slide. There is literally hundreds of pages of information available by the ARRC. They've issued innumerable consultations, what they call it, and recommendations. And you can find it at the website, which I've listed here. And what they've also done, and again, somewhat helpful, not completely helpful, but somewhat helpful, and we'll look at one example in a few minutes. They've created proposed draft contract replacement language for commercial adjustable rate mortgages, for bilateral business loans, your typical business loan between a borrower and a creditor, floating rate loans, securitizations, and syndicated loans. And keep in mind that in several of these categories, you may have several different levels of contracts, which may or may not utilize LIBOR, and may or may not require substitution. Next slide, please. Well, what people began to finally realize, including the ARRC, that there were a lot of moving parts here, and for a several billion-dollar loan, 25 basis points is worth fighting over. And there was no clear path of being able to fix this, even though they did adopt a statute in New York City for loans theoretically utilizing New York law, which is permissible for commercial contracts. But nevertheless, they finally began to understand the fact that this is not going to stop people from suing one another. And again, there's money in them, their hills. And so what they finally ended up doing is they ended up adopting the LIBOR Act. And we're going to go through the timeline, the purpose, the preemption that comes out of it, the applicability of it, the effect, as well as the modification of certain other laws that apply. Now, the timeline, next slide, went lickety split. They finally realized we really needed to do this, and we all, watch the news show about Congress cannot do anything. Well, they finally said, well, we really do need to do something here because this absolutely has to get done. And it began with the announcement of the so-called elimination of LIBOR. New York passed its law the month after, in April of 2021. Federal legislation was then introduced a couple of months later when we realized that this dog is not necessarily hunting. And what they did, and this happens pretty often, when there's something that you simply got to get past and you can't allow somebody to hold up the legislation, you put it in the Consolidated Appropriations Act, or you put it into the Defense Department bill, and that's how you get it passed. And that's what they did here. They put it into the 2022 Consolidated Appropriations Act, and then 2 days later, it was signed by President Biden as Public Law 117-103. What does it do? Next slide. Well, it provides a clear and uniform process to replace LIBOR in legacy contracts that have not adequately addressed LIBOR replacement. And we'll talk about a little bit about what it means to have not adequately addressed LIBOR replacement. It stems or mitigates litigation, and this in this case is very, very helpful. It does not interfere with contracts that have adequate LIBOR replacement, and it also addresses references in state laws. So it's actually very well drafted, it's well thought out, and it really helps us. And next slide. Just to be a little snarky, after all this nonsense that the ARRC went through, a bunch of guys sitting around a table, they finally realized they had to get national legislation, and they did that. And the problem with the New York law is that the New York law theoretically would apply to any contract issued under New York law, and New York statute allows you to do that for commercial contracts. But if you sued in another jurisdiction and another court interpreted what New York law would do, people realized that might not be adequate if you were applying New York law to a contract governed by New York law, but taking place in Montana. And so there are real concerns regarding state interpretations, and also for contracts which are not which are not swaps or derivatives. People were saying, look, this is not going to be adequate for us because of the margin issue, which again we're going to be talking about a little bit later. Preemption of state laws. Next slide. Here they did a good thing. Federal law preempts state laws in terms of interstate commerce, and it preempts, and the LIBOR Act preempts state laws, precluding the need of state legislation, which is a really good thing, because the last thing you want to do is to have state legislators talking about substituting $200 trillion worth of contracts in the proper way of doing it. Next slide. Now let's talk about the applicability of the LIBOR Act as a replacement methodology. And this is where, again, your risk management folks and operations folks have got to start making up lists. It covers just about every type of contract and indenture, leases, securities that use 1 month, 3 month, 6 month, and 12-month LIBOR as a benchmark. It does not include 1 week and 2 month LIBOR, which have been eliminated. And they eliminated them at the end of last year, but the 3 month LIBOR rate is the most prevalent. In the case of consumer loans, it's 12-month LIBOR. And in addition, it does a number of things in a number of categories. Contract counterparties can opt out of the federal legislation and go do their own thing. They want to sign on to it, that's great, let them go ahead and do that. What it also does is it nullifies fallback provisions, replacement provisions in contracts that are tied to LIBOR and are just not adequate for what we're dealing with here. And that's because many of the contracts assume, well, maybe for whatever reason, there's going to be a temporary disruption and LIBOR is not going to be announced for a 1, 3, or 4 month period. That's not what's happening. It's going away. And many of these replacement indices and provisions are not adequate enough to be able to address what's really taking place. Next slide. Well, what is the effect of it? It treats contracts differently depending upon their category. Contracts that have adequately selected a benchmark replacement and how you go about doing it. Contracts that have fallback language that gives a so-called determining person, which is a defined term, and that, somebody who's authorized to do it, the power to choose a benchmark. And contracts that have neither a determining person concept nor have chosen a benchmark replacement, because that was, again, another concern. What if it's just not clear as to what happens? Does that mean you end up with a fixed rate contract? That could wreck your entire day, depending upon what side of the lending aisle you're on. Next slide. This is an easy one. If you've got good language and the contract has selected and determined a benchmark replacement, the LIBOR Act has no effect on these contracts. People have been slowly but surely doing this. They're slowly but surely amending contracts and putting in language that they like. And hopefully that's in the category that you're in. Next slide. The next, and this is probably the most important one, contracts that have fallback language that gives a determining person the power to choose a benchmark. What it says is that it authorizes your determining person to select the SOFR and tenor spread adjustment and provides a safe harbor to the determining person if they do it. And you see here what those tenor spread adjustments are. So if you've got a determining person and that determining person says, we've got to go substitute, you choose the proper reflective tenor plus the adjustment factor, you plug it in and you're off to the races. Now, naturally, nothing is ever perfect. And because of the disruption in the marketplace, people are now pointing out that these adjustments may not be appropriate, and the Federal Reserve Board may have to come in and slightly modify them for June 30th of next year. It's not clear whether or not they can do it, but I'm sure that the Federal Reserve Board, since they are the masters of the universe, will probably find a way to be able to make the adjustments and claim the authority to do so. Next slide. Now, I know you're all asking, okay, we've got a determining person. What if the determining person fails to act? What if that person just says, I'm a scaredy cat. I'm not going to do this. I'm not going to get sued. What happens? Well, again, importantly, there's an answer here. And the LIBOR Act says that if the determining person does nothing, the proper SOFR tenor plus the spread adjustment, as a matter of law, abracadabra, automatically becomes the replacement benchmark on June 30th going forward. So if the person doesn't want to act, it happens. And that's probably the best protection that anyone can have, so that if you've got a determining person, or for that matter, another term is used as the calculating person that doesn't want to do it, this happens as a matter of law. Now, if the determining person decides not to use the appropriate SOFR tenor plus the adjustment factor and substitute something else, that's okay, they can do it. But what they don't get is the safe harbor, which means if somebody is objecting to the choice of the index plus the adjustment calculation, they have no safe harbor and theoretically can get sued. Next slide. And then you have a final category, which doesn't happen that often, but they're still out there. What if there's neither the identification of a determining person and there's nobody to choose a benchmark replacement? Again, abracadabra, it automatically becomes the appropriate SOFR index value and the spread adjustment as of June 30th, 2023. So if the determining person doesn't act, or if the language simply doesn't state it, you've got an opportunity here of being able to do something, protect yourself, and to make the adjustments, particularly if you're a debtor. Next slide. Other effects of LIBOR. And again, I'm sure all of you are sitting back saying, okay, I've got a promissory note, but I've also got a mortgage note. I may have a syndication note. I may have a bunch of collateral documents. I may have servicing agreements, all of which reference LIBOR or reflect LIBOR. And what happens if I amend the promissory note? What do I do about all the other stuff? Well, the LIBOR Act uses a term, benchmark replacement conforming changes, to say that the person who is now, as opposed to the determining person, the calculation person, can make as many changes as he or she or it wants in order to make the substitution operational for your transaction. The calculation person does not have to obtain consent from anyone. They simply get to do it, and they get to install the calculations and the adjustments on the various instruments or computer systems necessary to be able to make a calculation. Now, there's a recognition that how far out can this go? Well, it's probably going to require calculations by the Federal Reserve Board. But again, this is a very, very good result, so that you don't end up with somebody saying, oh, you forgot to do the servicing agreement, and the servicing agreement did not have LIBOR replaced. The answer is yes, servicing agreements would have LIBOR replaced, and it's something you can rely upon. Next slide. Safe harbor. I mentioned this, really very important. The LIBOR Act contains a safe harbor that used the replacement methodology in the LIBOR Act, and this is something which nobody likes paying legal fees, which is unfortunate. As a lawyer, you should pay as many legal fees as you possibly can. But that fact aside, I'm not a litigator, so I understand. There's no negative inference. And that means that you can't use the failure to comply with the LIBOR Act as an inference to create liability for a counterparty. And then also they threw in, well, the prudential bank regulators should not be allowed to beat up banks for doing something wrong, and that's in there, but that's really a minor point because the banking regulators have really not placed this as an enforcement priority. And then there's provisions which talk about the fact that after all of this is said and done, the instruments continue, the instruments are not voided, the instruments do not come to a grinding halt, and will continue on, and you are entitled to get the benefit of your bargain, and that's a good result. Next slide. Modification of other federal laws, and there's some things which have been put in here because people were raising their hands saying, this is really kind of important, we need to do. And probably the most important of which is the Trust Indenture Act of 1939. And that's used for where securities are generally put into trust, and doing that in a manner which authorizes someone subject to the Trust Indenture Act to be able to make payments, to make the substitution, to do the replacement. That's a good thing. There's also some references to the Higher Education Act, because a lot of student loans use LIBOR, which frankly was not necessarily a good idea when they did it. But anyway, that's been modified, again, somewhat of a minor point. Next slide. Okay, a project plan approach, and we're just going to take a few minutes to talk about what do you need to do in order to do this properly and address this properly, depending upon what your assets are that you're holding or you're managing. Next slide. Well, first of all, you need to identify categories of LIBOR impacted assets and what they're doing. what does this particular instrument do? How does it interrelate to other instruments? And you've certainly got commercial loans, you've got consumer loans, you've got secondary market transactions, again, because you can have stacked transactions and documents which interrelate with each other. You've got corporate trust functions, which we're going to talk about in a moment. And then you've got servicing functions. Well, I'm the servicer and I've got these documents in front of me. What do I do and how does it all interrelate? Then you've got to identify classes of LIBOR instruments within certain timeframes. Which ones are going to run off prior to June 30th of next year? And which ones are going to run off within specified time periods that you can identify on or after June 30th of 2023. And then you've got to identify in these categories what instruments have got effective replacement language and which ones don't. And I would note here, which I referenced a moment ago, ambiguous or incomplete substitution language, which may talk about, well, LIBOR, if LIBOR is not announced over the next 6-month period, here is what the rate will be, here is how we will do the substitution. That is all out the window. It's incomplete, it's ineffective. And so again, you have to identify that. And I would also emphasize for non-swaps and derivatives instruments, the absence or presence of the authority to adjust the margin on a loan. Next slide. Okay, so you've done that, and then you've got to decide which replacement index will be used for which asset classes. Will you use the SOFR? Will you use a forward-looking SOFR, which CME is now announcing and is licensing? Are you going to use the backward-looking SOFR? Oh, that's a question, and you need to get your economists and financial folks looking at that. Which of the tenors do you want to substitute? Is it the 3, 6 month, 1 year version? Are you going to be using the tenor spread adjustment? Also, too, are you authorized to be able to use the tenor spread adjustment? And that's an outstanding issue, which has not yet been resolved. And then again, what are you going to do about margin adjustments? One of the things that has come up for people in instances, and they've done this in most cases very favorably, where a borrower comes and asks for a loan modification. That gives you the opportunity, because of the existence then of consideration going both ways, of putting in place an effective LIBOR substitution provision that works for you. One of the things that has occurred, though, is that if someone is using SOFR and using the spread adjustment, oftentimes a creditor will say, well, we've got to increase the margin by, for example, from 15 basis points to 25 basis points. And borrowers have been very upset, saying what you're doing is you're spiking up the interest rate and you're penalizing me. That is not what's taking place here. What you're trying to do is level out the playing field by adjusting the lower SOFR value by adding on additional basis points to the margin. And it's probably a matter of educating borrowers as to what needs to be done. Also, too, on a go-forward basis, what the market is doing right now is people who are negotiating new transactions are negotiating adjustments to the spread adjustments and the margins being used for new financings or revised financings in order to take business and generate new business, which is an interesting outcome of all of this. Next slide. So now we've got multiple versions of LIBOR, and they've got to be prepared based upon the type of instrument, new instruments going forward, one category, amending existing instruments where it's possible to do that, possibly relying upon the LIBOR Act, complexity appropriate for the instrument. Now, the reason why I say complexity is that the ARRC has proposed some pretty complex substitution provisions, which are probably more appropriate for multi-million-dollar, $100 million financing schemes, which take place primarily in New York City as opposed to elsewhere. The LSTA has endorsed language and has got very useful language to take a look at. And institutional lenders are now falling back on what's known as the amendment approach to the elimination and substitution of LIBOR. Next slide. And by that, I mean there's two types of substitution language. One is the hardwire approach or the amendment approach. The hardwire approach is really getting into the weeds, being very, very specific, talking about a benchmark transition event, indicating exactly what is going to occur, and also indicating at what point the substitution can take place, such as a public statement by an entity indicating the index, that the LIBOR index has ceased being announced, or that it's no longer reliable. I'm kind of concerned about somebody saying the index is no longer reliable, because I guess for the last, move back. All right, now move one step forward. Okay, and the reason why it's the reliability issue is a concern is because you can argue that LIBOR has not been reliable for a long time. It's been, a bunch of guys raising their hands and saying, here's what I would bid on this. And whether or not a synthetic LIBOR going forward is a continuation of LIBOR, if it follows and tracks formally what was LIBOR, again, issues which have to be resolved. They are minor compared to the overall benefit that the LIBOR Act has put on the table for us. The amendment approach is that it merely indicates when a replacement event occurs, the determining person and maybe the calculating person substitutes the replacement index, and it's short, it's sweet, it's easier to do, but it relies upon the LIBOR Act, and that's what a lot of people are doing, because you don't want to have a 3-page promissory note followed by a 4-page replacement provision in your loan documents. And that segues into the next section, next page, which we're not going to read, but this is just an exemplar of the, I'm going to say gobbledygook, but very, very extensive language that the ARRC issued for bilateral business loans. So that's page 1. Next page. That's page 2. Next page. That's page 3. And oh, let's do another page. That's page 4. And you can read it, and it's very thoughtful. It's not something that may be useful in all circumstances, maybe not in many circumstances, but it was an approach. And there are other exemplars out there for much more boiled down approaches, which again may rely more upon the LIBOR Act and may not be suitable for smaller dollar amount loans to be used. Next page. As I mentioned, when you go through this analysis, then you also have to identify transactional documents that account for the secondary effect of LIBOR replacement. And the calculating person, as I mentioned before, can implement benchmark replacement conforming changes, which helps you out quite a bit to be able to get this all done. And so the important point here is to make sure that you are having communications with people who maybe have authority for purposes of calculations or administration or whatever, and identifying those documents which are necessary for purposes of being able to go along with the issues accompanying the benchmark replacement. Next slide. People have a tendency of putting stuff off, and a lot of people, when the announcement was made that we're going to be doing LIBOR replacement effectively the middle of next year, gave all the files to their subordinate and said, "Hey, Larry, put these away and we'll take care of it next April, May, or June." Well, it can potentially be more complicated than that, and it could be much more intensive than that. And we would not recommend that you do that, even though some people may simply decide out of sight, out of mind. The easy part is new language and for new deals. If you've got new deals, you should definitely have at this point effective LIBOR replacement if you're still using LIBOR, or new index selection plus replacement language for the in case for whatever reason that index decides to go away. For legacy deals, you've got to come up with your timeframes, your runoff dates, the opportunity to be able to renegotiate. In some cases, people are actually going to borrowers and suggesting an agreed upon approach towards being able to do it. So there's no one size that fits all. But at the end of the day, in most cases, the LIBOR Act will help most of you. Next slide. Okay, I wanted to mention this because this is could potentially be kind of important depending upon what your business model is and what your asset is. And it has to do with special cost corporate trust issues. As you know, corporate trustees provide trustee and agency services for note offerings and lending transactions, which involve numerous asset categories that include LIBOR. There can be floating rate notes, mortgage-backed securities, CMBS, CLOs, syndicated loans where somebody is acting as a loan agent, and commercial mortgages. Again, very typical to be using a trustee. Next slide. I wouldn't say that corporate trustees are scaredy cats, but they are scaredy cats sometimes, because the last thing they want to be doing is incurring liability when all they want to do is do their jobs. And they can take legitimately the position that their authority and obligations arise by the transaction documents. And there may not be authority for a corporate trustee to be acting to substitute LIBOR, and the corporate trustee may really have the power of the pen to be doing it. And it may not be clear also in terms of the documents whether or not a consent of majority of all note holders or other holders will be required. And you end up with some complex situations of determining, should I act, should I not act? Are there contrary issues here which may create liability if I'm a trustee? And the last thing that they want is litigation, because the issue then becomes, if I've got to defend myself, is this something for which I can be indemnified, and who's going to be paying for it? Well, one of the things that has arisen in the next slide is, next slide, is something known as a trust instruction proceeding, also known as TIPS. They're available in many states. In some states, they may be couched as a request to an equity court for instructions, but it's effectively a declaratory judgment to obtain a court direction to resolve LIBOR obligations. And people are now thinking about doing this. For example, a TIP is generally used to resolve a dispute or an error regarding a trust instrument. When remedial action is necessary, this was never contemplated and we have to do something and we don't think we have the authority to, or you end up with a dispute among holders and you laid at the doorstep of the court saying you decide it's not our job. And that is something which can be of definite benefit to you to consider, or to a trustee to be considering. Next slide. What does it do? Well, it protects the trustee. It provides a control forum for all points of view to be heard. It allows you to settle something without having to provide an indemnity. And if you're a note holder, you wouldn't necessarily want to be doing that, because that's extending your risk in favor of a trustee. And I also mentioned the fact that in New York, there's a streamlined procedure for effectively doing the same thing. And so again, a lot of trustees are looking at this, and it may end up being a belt and suspenders approach to be getting a court to sign off on whether it's a LIBOR Act action or amending the agreement and instructing a trustee as to how to proceed, either directly utilizing LIBOR Act authority or some other approach. Next slide. And here's my favorite, and that's consumer mortgages. There's now 1.2, maybe 1.5 trillion of consumer mortgages using LIBOR. The estimate is that there's going to be a runoff of them down to $800 billion of mortgages as of 2025. The GSEs finally stopped purchasing LIBOR-based mortgage loans, and so people are now no longer doing that unless they're holding them in portfolio. And the important point is the next slide. If you take a look at what we will term legacy Fannie and Freddie promissory notes, you will see that there's abbreviated language, which indicates that if the index is no longer available, the note holder will choose a new index, which is based upon comparable information, and will make a substitution, but there is no reference to a margin. And so the question becomes, how do we do this? There could definitely be circumstances in which a borrower could have a windfall because we can't adjust the margin. Could the GSEs adopt the SOFR approach and substitute a 1-year tenor plus a margin adjustment? Possibly. They refuse to tell us, but we have got a ton of mortgages which are theoretically subject to this adjustment, and most likely the entity making the adjustment would be the GSEs. Again, a very, very significant issue to consider. Two final points, and then we can take some questions. Next slide. The authority for making variable rate mortgage loans in the consumer side is based upon the National Bank Act and a comparable statute for state banking entities, which indicates that in the substitution or the use of an index, it must be readily available to and verifiable by the borrower and not beyond the control of the bank. And what happened, next slide, when the national banks got the authority, the variable rate authority under the Alternative Mortgage Transactions Parity Act, which was several hundred years ago, was adopted, which adopted comparable language. And so what you have is, if you will, an overlay of what is a requirement for being able to use a variable rate index, which must be readily available and beyond the control of the bank. And I will tell you in closing, if you really want to read gobbledygook, you can read the CFPB's interference in this whole process by issuing a several hundred-page description of what is necessary in order to do an index replacement for a consumer loan, which frankly they had no business doing. They should have remained out of it. They could have expedited the process. But if you're dealing with consumer mortgage loans, it's another level of complexity in terms of timing and notice and disclosure that frankly the CFPB should not have done, but they did anyway. And whether or not they end up fixing it within this next year, we will find out. But anyway, having said that, since as you can probably tell, I don't like the CFPB much at all. I just want to close saying there is a process for moving forward. It requires some deliberation and probably some planning on the part of your operations folks as to what's going to best suit your risk model, your risk tolerance, and what the characterization of your borrowers are for purposes of moving forward and either relying upon the LIBOR Act or relying upon documents and contract language, which you can identify through a due diligence process. That is a whole lot to absorb in a short period of time. I understand that we will have an opportunity to take a few questions, and I'd like to thank you for your time.
Excellent job, Joe. We did have one question come in. This is, not sure I am understanding the spread adjustments. Are they permanent changes to the transition rates or temporary and will just ultimately go away?
No, they're intended to be permanent in that what they're intended to do is to adjust for the difference between what a SOFR value is and what the LIBOR value is. So I would not call it an end around about doing a margin adjustment, but it's an attempt to correlate what is the value of SOFR in one of these tenors, the 3-month, 6-month, 12-month tenors, by adding a factor to it to roughly make it equivalent to what LIBOR would be. The problem, though, is it may not be an effective rate when we start doing this several months in advance. There may be a growing distance between what LIBOR theoretically could be and what SOFR would be, in which case, if you use it, you're locking yourself in to a income stream which may not be satisfactory after the fact, but it is intended to be permanent.
Great. I have another one. What are the key impact of the CFPB's final rule to facilitate transition from LIBOR, e.g. Reg Z, disclosures, etc.?
Oh, good question. The CFPB's regulation indicates that, and again, in a poorly written but very complex regulation, you've got to comply with Regulation Z disclosures when you change the interest rate on a loan, recognizing the fact that the interest rate here is going to change in an unusual situation. And you have to calculate, again, this is again with reference to Regulation Z, that you have to give people advance warning of a interest rate that will be taking place several months in the future. And so you've got to notify them, and they've got several different notices which theoretically can be sent out. So again, you can process these requirements depending upon the size of your servicing operation. It can be somewhat complex as compared to the better answer should have been, you can make the adjustment and send out an after the fact notice to people. Doing this looking forward several months may be very difficult to be able to achieve. And again, it probably was not worth the effort on the part of the CFPB, except that they interfere with just about anything they can nowadays. And here they've done a terrible job. But it's gonna take some time and effort to parse through what you are going to have to do in terms of your notification, because again, it's going to be looking forward before you turn the key on June 30th of next year to insert the proper index value.
Thank you. And last question. What provisions does LIBOR Act make for loans in current default as relates to the transition of rate index?
I'm sorry, could you repeat that again?
Sure. What provisions does LIBOR Act make for loans in current default as relates to the transition of the rate index?
That's a good question. It probably would not have any impact except to the extent that there becomes a replacement event, and you would be, again, because you can put in conforming changes, you would likely take the position that we are then placing into what was amounts due and payable under a LIBOR calculation, the SOFR or other replacement index calculations. So it should not have any impact except again, a replacement event. And that would be my initial thoughts without looking more clearly at language.
Fantastic. Thank you so much, Joe. And I'd like to offer some time up to Harriet. We missed her at the very beginning, but fortunately we were able to get everything all squared away. So Harriet, if you'd like to take a second just to introduce yourself and talk a little bit about what you do.
Yes, thank you. Hi, everybody. I'm Harriet Alexson. I know many of you in the Orange County RMA. And I was going to be doing the introductions, so I will do the conclusion. And I want to thank Joe for his very timely information. And I also wanted to add that Joe's idea about doing a project plan or looking at your loans that might be going into default, it's very important. And, you know, address your portfolios before the time crunch hits. I am of counsel with the firm of Lee Hong, Dagerman, Kang, and Wamey in the Newport Beach office. Our firm is full service, and Lee Hong lawyers provide expert representation in litigation, transactions, and business and regulatory matters. The firm has international offices, so we do cross-border transactions as well. My practice includes transactional work, complex mixed collateral loan documents, loan workouts, private equity, financial service regulation and licensing. And at this point, I have been doing quite a few fintech partnerships where a financial institution, let's say a community bank, might want to increase their originations. So they might want to look to a mortgage lender or broker in a partnership to be able to do that with a technology platform. I also serve as an expert witness in cases relating to Article 8 and 9 of the Commercial Code and various financial regulatory matters. I am currently the chair of the banking and lending section of the Orange County Bar Association, and we put on monthly programs in areas of, you know, new legal requirements, new laws. And so in that capacity, I am doing training, and I appreciate John and Chris inviting me to host this panel. And of course, I appreciate Joe preparing this very important information for us.
Excellent. Thank you so much, Harriet. Thank you again, Joe, for this awesome presentation. I didn't see any other questions come in from that side. So in that case, we'd like to wrap it up. We want to thank all of our attendees for joining us today for this great educational event. If you are watching it recorded, please be sure to check out our entire YouTube page. We put all of our education programs up there, and it's just a nice little depository for all different types of information and backgrounds regarding risk management practices, banking, finance, you name it. So we thank you again for attending this. Joe, again, thank you for your time and expertise. Harriet, thank you so much for organizing this and making it an excellent presentation. So from on there, we'd like to also say we have an upcoming CEO panel for the RMA Orange County. We'll be featuring 4 different CEOs from around regional banks. We'd love to have you there if you could make it and attend. So please check it out. It'll be on Tuesday, June 7th, and we'll be hosting that at the Pacific Club. But without further ado, I think that's time to wrap us up. So again, thank you for coming. Thank you for attending. And yeah, we'll hope to see you on the next little Zoom call. Thanks again, Joe. And take care, guys.